The North Gauteng High Court in Pretoria has set aside Public Protector Advocate Busisiwe Mkhwebane's report on the so-called SARS Rogue Unit. Now, in its judgment, the court issued a punitive costs order against Advocate Mkhwebane. The Public Protector's report found that former SARS Commissioner Pravin Gordhan, who is currently the Minister of Public Enterprises, had misled Parliament by failing to disclose that he held a meeting with members of the Gupta family. Meanwhile, the Judicial Conduct Tribunal of Western Cape Judge President Judge Hlophe is expected to enter its second day today, with Justices Bess Nkabinde and Jafta expected to give evidence. Hlope faces a charge of gross misconduct for allegedly trying to influence the two Constitutional Court judges in 2008 to rule in favour of former President Jacob Zuma in a then pending Constitutional Court case. So let's discuss some of these matters with attorney Casper Badenhorst. Thanks so much for your time. Welcome to Morning Live.
Thank you very much. Good morning.
Let's start with the Public Protector. Now, yet another case set aside for the Public Protector. So this latest judgment around the SARS Rogue Unit case as well. Firstly, what do you make of it?
Well, it's quite a scathing judgment. I mean, this is in the scale of what the Public Protector's had to face over the tenure of her position as the Public Protector. This is probably the most scathing judgment that she's received. I mean, it goes as far as the judges referring her conduct to the LPC, the Legal Practice Council, which in essence really means that they do not believe, or they believe the conduct that she's displayed in her preparation of the report is unbecoming of a legal practitioner. One mustn't forget that she is an advocate, and she's also accountable to an institution such as the Legal Practice Council, and that they believe that the way that she had conducted herself requires an investigation into her position as an advocate. So all in all, I mean, the judgment is very scathing. I mean, it really pokes holes into every bit of determination that she made in terms of her report, to such an extent that they do not believe that there was any sort of sound reasoning or lawful basis upon the grounds that she made such conclusions against the minister and Mr. Pillay. So definitely, it's very scathing.
How does this, Casper, for you, then come together with the issue of the SARS Rogue Unit? Where do these two cross?
Well, I mean, it obviously, they spoke a lot about a bias that the Public Protector had against Pravin Gordhan and Minister Pillay. And I mean, it really shows that there was obviously a preconceived idea by the Public Protector, or at least this is what the judges have found in their judgment, that there was a preconceived idea that there was already going to be made a determination on the Rogue Unit, or the so-called Rogue Unit. I mean, this is now found in law to be a completely legal entity. That it wasn't as sinister as the Public Protector has made it out to be. I mean, on a legal basis, that is what the determination, or the current determination on the Rogue Unit is. Politically, maybe not so much. There will always be people that would like to, consider the Rogue Unit as what the Public Protector has made it out to be.
So, and I want to probe that a little bit further, because I've always been of the view that this should be a fairly simple question about whether that unit that was established by the South African Revenue Service was operating legally or not. And it's actually quite fascinating that it has become such a contentious issue. What are your views on that?
Well, I mean, as I say, I think, it's obviously been punted as a legal structure, something that was incredibly sinister and out to get people. I mean, and that's been the line that's been punted all along. The judges have now determined that is not what it is. The Public Protector had evidence before her that she didn't even consider. So all along, although people would like to determine or to consider the very sinister nature of what has been said to them about the Rogue Unit, that has now, by 3 judges of the High Court, been determined to be a complete farce. It's untrue, and that, as far as its legal establishment is concerned, it's totally within the law. And it was done correctly.
But where do we find that? Where is that established? Because that's one of the questions that I want us to grapple with, the legality of that particular unit. And maybe let me start by asking you, what is the legal standing of this Kakane report?
Well, I mean, this Kakane report's been found to be incorrect. I mean, that has already been determined to be discredited, and
by
on that
whom?
basis, I mean,
by whom, Casper?
It's been. I'll need to look into that a bit further, unfortunately.
Because, and I ask this because remember, this Kakane report was commissioned by Ivan Pillay, who at the time was the acting commissioner at SARS. And it was to investigate the conduct of Johan van Lochrenberg then after, that dalliance that he had with Belinda Walter, who was an attorney with some of the tobacco companies that were being investigated. And she had laid a charge. She had made allegations against him. Ivan Pillay then appointed the Kakane Commission, and they had to look into this matter. But it is widely said that the Kakane report has been discredited. But one of the things I'm failing to find is who discredited it, when, and if it was discredited, how was it discredited? Because wouldn't one expect the protagonists in this particular instance to take that report on review?
Certainly. So, I mean, if that is the case, and I will have to look into where it comes from, the allegation. But I mean, if it is definitely that some entity has discredited, then a review process, or rather not a review, but an appeal process needs to be undertaken to determine whether the report, having been discredited, was done so on a legal basis. I mean, a review is generally when there is a bias acted in terms of how the conduct of a process has been conducted. So if there is a determination by someone that would like to consider the legality of the discrediting report, then that certainly should be a process that must be undertaken.
Because I went and read that report again last night, and then you had, of course, the Kruin report, and Judge Kruin actually withdrew his report because he had said to the Nugent Commission that he based his report practically wholly on the Kakane report. But does the fact that Judge Kruin withdrew his report mean that the Kakane report is discredited?
Look, it certainly will. Let me put it this way. I mean, I don't think this is the end of the current case of the Public Protector. I'm sure that there will be an appeal into this. These types of aspects as to the effect of various reports that have been said to be discredited and then to be withdrawn will come into play, and those are aspects which will be appealed on the basis of law. So certainly that will come into play at a certain stage. It does give it certain weight in the fact that the one report is based on the other, which may have been discredited. Those things will come into play eventually. So certainly those are aspects that will need to be considered.
But we still haven't determined who discredited that report. And by the way, going to the Nugent report, one of the things that Judge Nugent stated was that SARS should re-establish capacity to monitor and investigate the illicit trades in particular and the trade in cigarettes within appropriate governance structures. And isn't that important in terms of the question around the legality and the lawfulness of the unit that was established by SARS, because the commissioner at the time when this particular unit was envisaged was Pravin Gordhan. And he admitted, he asked Treasury to give additional funding to the NIA so that they could assist SARS with this capability, because it fell outside of the scope and ambit of the Revenue Service, and they did not have a mandate to conduct some of those investigations or collect the information that they wanted.
Yeah, look, as I say, these are all points that the Public Protector will most likely bring on an appeal. The judges in the current matter found that there is no legal basis upon which she actually determined her current report, on the basis that there was obviously an evident bias, and it's unbecoming of her position as a public protector. The rabbit holes that one can go down in terms of which reports said what and how they were treated eventually, those are certain aspects that can be determined. The latest position on this matter, however, is that the judges have found that her report is not based on any sort of rational process, and its factual basis is incorrect. Her understanding of certain sections in codes are misunderstood, and on that basis they have found that that report is incorrect. But as I say, all of these are aspects that will most likely be ventilated in greater detail when it goes to appeal, if it does go to an appeal process.
I must say, it's actually fascinating to watch all of this play out. Now, the court found that the Public Protector was actually biased in her investigation. So if you look at that, it's a scathing judgment of bias, of course, leveled against the Public Protector. And obviously, this affects the public's confidence in the Public Protector's ability to actually conduct her duties. And it's not the first, as we said, it's one of several reports that have now been set aside. But what does this mean for the Public Protector after this particular judgment and her office?
No, it certainly does reduce the credibility one feels towards the Public Protector. This is now a string of judgments that have gone against her and have dealt with her competency as a public protector, or as the incumbent of the Public Protector. So certainly, sorry, I've just got a phone. Certainly that is, her credibility is called into question, and that will certainly be difficult. The fact that she's in her report, she mentioned that she didn't have certain other reports available to her, but then changed her story in respect of that. Those are all aspects which have been pointed out, which bring into question her credibility. It doesn't lead it to a position where she can be summarily removed from her position as a public protector. That is a parliamentary process, because she still is the public protector. There needs to be a constitutional protection of her position. But I think going forward, it will lead to some mistrust in terms of her credibility.
And then another punitive cost order against the Public Protector, again, not the first. And just in terms, again, of her continuing in the position, if you have these cost orders piling up, what does it mean for her in that sense? Does it start to make her position untenable in that office?
Yes, I think there'll certainly be others within the Public Protector's office that'll have issue with that. Many of the cost orders, this particular one was split between her paying personally and as well as the Public Protector's office paying. But there will be others in higher positions within that office that will start to feel that the continued slew of applications that she is losing and the cost orders she is gaining will start to result in some damage towards the Public Protector's office. So it certainly, unless they support her fully in these cases and they feel that they are justified, then I'm sure they won't be so reticent to pay such cost orders. But certainly they will start to incur some damage to that office.
And then, Casper, another prominent court case yesterday and seemed to turn on a certain phrase that was brought into question, Stembele Gunina, which could be translated to mean you are our last hope. And this, of course, in the case of the Western Cape President Judge John Hlope, allegedly trying to influence Justices Jafta and Nkabinde in favour of former President Jacob Zuma. This phrase and all the evidence that was led in terms of the use of that particular phrase, please talk to us about that and whether you believe from the evidence that was led yesterday that phrase could have been taken out of context.
It's a very interesting matter. It's before the tribunal at the moment now for Judicial Service Commission, and it comes to a very subjective nature of how did Judge Hlophe say this or make this statement or comment to the justices, and how did they receive it? How did they take it, interpret it? And that becomes a very, very subjective issue. So, I mean, with the evidence led yesterday by the expert, Mr. Matsenjwa, he's obviously taken that material and what he has said is that he's considered everything within the context of how it was said, what the meeting was about, and all of the surrounding circumstances to try and piece together what the context of that statement was, and whether it was just to say, well, you are the justices of the Constitutional Court, and we hope for correct or determination on this issue, or whether it was to say, please help, to put it simply. I mean, so it is a very interesting, it's gonna come to a point of a lot of subjective understanding of how it was said. It is the correct manner in bringing experts to try and determine a phrase, also because that's what it comes down to. It's an interpretation of language. So certainly you will need to have experts in that field to understand the circumstances surrounding when that statement was made. But obviously there are many questions into his approaching the justices and why it was done, and those will be probed a bit further. But certainly an interesting matter.
Certainly is. And of course, Casper, there is no law barring judges and lawyers from speaking to one another. However, it does beg the question of ethics and whether judges, prosecutors, lawyers, etc., should discuss cases outside of the courtroom.
It's a difficult one in the sense, there are set processes and how one should go about discussing matters with colleagues and so on. It's a small fraternity. I mean, it's not a big industry really. So the likelihood of matters being discussed will always be there. The correct process and what an important rule in our profession is that when you're involved in a case, being if myself and my opponent needed to speak to a judge directly, you would do it together. You wouldn't go separately and discuss matters. That is a definite no-no. You cannot do that. But as far as, me or any other legal profession or discussing a matter with a colleague, unless there is some sort of influence that they could possibly bear over that matter, they should also, exercise some discretion in how they go about things. It certainly is as a matter of determining whether your actions are going to result in some sort of, concern at a later stage. And I suppose judges are placed at a higher understanding of that. I think judges are generally reviewed as not acting in such a strange manner of discussing matters where they have no say in this particular matter, but where they discuss it in where it seems to be that they are trying to sway a certain position. But it will be difficult to bar judges and attorneys, or rather attorneys with each other and advocates with each other, attorneys and advocates from discussing matters with each other. That will always be difficult to control. But as I say, certainly the big issue and the issue that one should never do is where you are involved in the matter and speak directly to a judge without your opponent present.
And we're out of time, but just a quick one, Casper. It's taken 12 years to get this tribunal going and looking into this matter. Should we read anything into that or not?
Well, the understanding is that these delays have really been caused by, the slew of cases that have been brought over the past few years. It's been, I think they've said 14 matters that have been brought by various parties. So, the delay is there, and it's unfortunate. It's good that it's coming to a conclusion now. But unfortunately, that will at times occur where matters are delayed for decades as a result of interlocutory skirmishes or matters being brought to review certain things. Whether to read anything into that at this point is difficult to say, other than we should just be thankful that it's coming to a close.
Well, Casper Badenhorst, thanks so much for your time helping us analyze two prominent court cases yesterday, that of the Public Protector Busisiwe Mkhwebane's report on the so-called SARS Rogue Unit that was set aside by the North Gauteng High Court in Pretoria, and also a certain phrase called into question relating to whether Western Cape Judge President Judge Hlophe intentionally tried to influence Justice Jafta during a meeting 12 years ago to win over justices to former President Jacob Zuma's side in a then pending constitutional court case.